right, Mr. Johnson, would you state your name and DSC number?
Yes, ma'am. Brandon Johnson, 409537.
We may have lost the audio there at DOC, so I'll pick up for him. Mr. Johnson, my name is Cheryl Renatza. I'll be reading some information into the record, ask you to confirm it. We'll hear, and let me just ask your attorney if she would introduce herself for the record.
Morning, members of the board. Jane Hogan here on behalf of Brandon Johnson. I'm also in the room with his mother, father, stepmother, stepfather, 2 aunts, 1 uncle, brother, sister, fiance, and future mother-in-law. Thank you.
All right, welcome everybody. And we also have with us a representative from the DA's office, Mr. Kurt Wall. So, Mr. Johnson, as I said, I'll be reading some information into the record. Your case has been assigned to Mr. Wise, so I'll turn it over to him after that. He'll be asking you some questions. We'll hear from the facility warden, Falgu. We'll hear from those who are there with your attorney who've indicated they'd like to speak. We'd also hear from the DA's office. And at the very end, you'll be allowed to make a statement, and then we'll ask Ms. Hogan to wrap it up for us. Okay?
Yes, ma'am. Thank you.
All right. You are Brandon Johnson, DOC number 409537. You are classified as a first felony offender, and you're currently serving a life sentence for a second-degree murder conviction out of East Baton Rouge Parish, and you were sentenced April 18th, 1999. Is that information correct, Mr. Johnson?
Yes, ma'am.
Okay, would you answer Mr. Wise's questions, please?
Yes, ma'am. Thank you.
Mr. Johnson, when you came into prison, how old were you?
19 years old.
You was 19 years old. That was, as I can see here, your criminal history, you don't have a big criminal history here. You're classified as a first offender. But during this time after you came in, what classes did you start taking? I know it's a little while before you start taking. Did you take a good many classes?
Yes, sir, I did. I've taken.
What do you think? What do you think was probably one of the best classes that you've taken? I see where you've taken several classes.
Thinking for a change has really been a big factor in my life because it has taught me about decision making and the decisions I make, how it can affect the lives of others and also change my life and affect my life.
Yes, sir. During your time, I see that you have 19 disciplinary reports. Is that correct?
Yes, sir.
And your last disciplinary report would be on 2/27/14 of 21D. Is that correct?
Yes, sir.
Okay. What is your job title at the prison where you at? What do you do?
I'm currently a reentry social mentor.
How long you been doing that, Brandon?
For a year and a half.
Are you classified as a trustee?
Yes, sir. Class A trustee.
How long you been a Class A trustee?
Since 2014.
Since 2014.
Yes, sir.
If you were to go through this and make your way out, where would you go live?
With my mother.
Is it anything you'd like to say to the victims of this case on any matter, on this matter?
Yes, sir. I've taken victim awareness, and that is a class that has taught me and shown me the pain and suffering that victims go through. No one could ever understand the hurt. And I'm very, very remorseful for that. No one deserves that.
All right, Brandon, how long have you been incarcerated?
for 23 and a half years.
23 and a half years.
Yes, sir.
All right, I don't have any other questions.
Thank you, Mr. Wise. I see Mr. Roche has a question.
Thank you, Madam Chairman. Good afternoon, Mr. Johnson. How are you?
How you doing, sir?
Good. Mr. Johnson, tell us about any community service other than you're a mentor in a reentry program. Tell me about any other community service that you've rendered to the fellow offenders during your 23 and a half years of incarceration.
Yes, sir. I am currently a hospice volunteer, and hospice has shown me the true meaning of compassion, putting the need of others before myself, sir, taking care of people who can't do for themselves, and just being a bright spot in a dark time in their lives and being available. I'm also in Louisiana Prison Braille program. That's an extension of Louisiana Special School District, and I'm able to, and I'll be able to transcribe school books for kids that are visually impaired and are blind, so they can have the same opportunities, sir, as other kids.
Okay. Any organizational participations like Toastmasters, JSCs?
No, sir.
Do you belong to any organization at Louisiana State Penitentiary?
Hospice. I'm a hospice volunteer.
Okay. Okay.
And leadership. Okay.
And Mr. Johnson, I'm going to ask you briefly. I've read all the information. I had nothing to do with the process of your arrest, conviction, but I do remember the reports on TV the day that this particular shooting happened.
Yes, sir.
Can you briefly tell us in your words what happened that day?
Sir, I want this board to know that I accept responsibility because I have been legally convicted of second-degree murder, sir. I'm very remorseful, and I'm definitely not trying to cause any pain to anyone.
Mr. Johnson, let me stop you there. I understand exactly where you're going, and I think it would be best if I would conclude my questioning at this point. Madam Chairman?
Thank you, Mr. Roche. Warden Falgout, is there any input you can offer?
He has spoken about his time with the hospice program as a volunteer. He's been an asset to that program. He's done a good job for us on the tutoring and as a mentor. And again, he's only had 19 write-ups in 22, 23 years. So he's been a good offender here for us and has done some positive work here for us.
Great, thank you. Thank you. So we'll hear from the folks here in support. Ms. Hogan, would you introduce those who'll be speaking?
Thank you. Speaking first is Brandon's mother, Elizabeth Johnson Jackson.
Good afternoon. I want to say thank you all first for giving us a chance as a family to hear us. I'm Brandon Johnson's mother. I'm Elizabeth Johnson Jackson. I'm very proud of my son and the accomplishments that he has made in the 23 years that he's been incarcerated at Angola. I wanted to let you all know that my husband and I are homeowners, and I'm also a provider for the Louisiana Department of Health and Hospitals. I own a pre-vocational facilities for the physically challenged adults. If God grants Brandon clemency and he comes home, he would come home to a stable environment where he left from. He would have a job. I miss my son. I love my son. I'm very proud of him. I'm very proud in the different acclimates he have had at Angola, tutoring, being a part of the hospitals. And it just lets me know that God has something in store for his life. And I want to thank you all again. I know it's only 2 or 3 minutes, and as a mom, I can tell you a whole lot. But I just want to say thank you, and God bless you all and your families. Brandon, keep your head up, do good, and continue, son, to do what's right. Thank you all.
Thank you.
And next will be his father speaking.
Hi, I'm John Jackson. I'm Brandon Johnson's father. I watched my son over the last 23 years grow into this amazing man. He has come a long ways. He's very positive. He's very strong. He also has a lot of support from his family. We love him. We want to make sure that he's always on the right track. And I would really appreciate if he comes home. Thank you.
Okay, next, I think we'll hear from Kurt Wall, the ADA who prosecuted the case. He's in Livingston now, but was in East Baton Rouge at that time.
Thank you, Madam Chairman. I appreciate a few minutes to chime in on this case. Thank the board, and I also spoke with Mr. Tony Clayton last week, who was involved in the prosecution of this case, and we spoke about it, and he allowed me to speak on his behalf, which, if you know Mr. Clayton, that's very rare indeed. But I will proceed. I actually was a pretty young prosecutor when this case came into our office back in 1998. I'd only been prosecuting cases about 4 years at that time. But I vividly remember, even though it's been a couple of decades since that case, I vividly remember the day that it happened, just like Mr. Roche mentioned. It shocked the community. It sent shockwaves through the community of Baton Rouge because not only did it make local headlines, but because of the nature of the event and when the event happened during the Martin Luther King parade, it made national headlines, and it gave our city somewhat of a black eye at the time, because even though it wasn't necessarily racial in nature, that was the perception nationwide when they saw the headlines of what had happened. I do remember that Mr. J.B. Carter, who was the victim, one of the victims in this case, who was killed in this incident, was also very young. I believe he was 20 years old at the time. And there were 3 other individuals that were injured during this event that may have gotten overlooked to some extent, but there were 3 children that got injured at this parade. One was 8 years old, Shanice Anderson. There was another one that was 9 years old, Michael Chen. And then there was an 11-year-old young lady named Alicia Gibson, all of whom suffered gunshot wounds at this parade. I will say very briefly, I did review the entire record. I reviewed Mr. Johnson's statements, his family's statements. I reviewed the accomplishments that he's made while he's been incarcerated. And what I will say is I was a little bit disappointed with the statements from Mr. Johnson. I did see that he said that he accepts responsibility, but that was sort of where it ended. He didn't comment any further, which is troubling to me. But on a day that was reserved to honor Dr. King's peaceful legacy. Like I said, this incident still stands out. Frankly, I don't think that parade has ever been the same since that day. And I'm certain that those 3 children that attended the parade on that day have never felt the same about that holiday since that day. I will say on Mr. Johnson's behalf, I think that he comes from a good family. I think that he has a lot of support. I don't think that he's necessarily a bad person. I applaud him for using his time during his incarceration to, especially with the hospice situation. You know, that is a very challenging position to fill, to sit there and help people who are going through a hospice type of challenge. I do think that perhaps one day that he should be considered for commutation. However, at this particular time, I do not feel that he has served enough time for the incident that happened back then, and the 4 people that were injured, and 3 that were injured and 1 that was killed. And therefore, at this time, Mr. Clayton and I oppose. Thank you for my time, y'all. Ms. Chairwoman.
Thank you. Thank you. Mr. Johnson, is there a statement you'd like to make to the board?
Yes, ma'am. I would like to thank the board for giving me this opportunity to speak. I am deeply remorseful for the death of Mr. James Carter, the harm that was caused to Ms. Shanice Anderson, Ms. Elise Gibson, and Mr. Michael Chin, their families, and also their friends. There's not a day that goes by that I don't ask God to work on all of me, to lead me and guide me to be a better person so I can be of value to other people's lives, ma'am. And I'm striving every day to be more compassionate, more considerate, so I can help other people who are in need, ma'am.
Thank you. Thank you, sir. Ms.
Yes,
Hogan?
ma'am.
Thank you, Ms. Renatza. Very briefly, although Brandon wasn't really given enough time to explain anything, he has maintained his factual innocence for the last 23 years. We know that that is not the purpose of a hearing such as this, but that fact remains that this was a 15-day trial. The jury was deadlocked for days. There was an alternative suspect. It was there was no physical evidence or surveillance footage or anything like that that actually showed that Brandon was the one that had fired the gun. He attended the parade that day to volunteer as a band parent with his mother. His younger sister and brother were marching in the band. Brandon had absolutely no criminal history. He was enrolled in Southern University. He was working for the Department of Corrections part-time at Dixon Correctional Center. In spite of his circumstances, we know that this is not the place for that. We are asking for mercy and clemency based on the last 23 and a half years. The amount of community service that Brandon has exhibited is remarkable. He made the best. He went above and beyond in an awful situation. And in addition to his 8 years as a hospice volunteer, his work in the Braille course, and his current job as a reentry mentor, he's also been a healthcare orderly. Within a week of getting to Angola, he was a tutor. He has taught dozens of men how to read. He has spent time with younger and older men, teaching them literacy skills. And I believe that the letters that we've submitted in support with the brief that we submitted from Tanya Fowles, the coordinator of the hospice program, and other people, it really just shows that Brandon's level of commitment to his fellow man is just exemplary. So based on the 23 and a half years and this extraordinary case with this extraordinary man, we would ask this board to consider granting Brandon a commutation to either a term of years that would allow him for immediate release or to 99 years with immediate parole eligibility. He has overwhelming family support. In addition to the 11 people that are here gathered today, There are about 30 or 40 people watching today on YouTube in support of Brandon as well. So we would ask this board to make that recommendation. Thank you so much.
Thank you, Ms. Hogan. Um,
Madam Chairman,
I think, yes, sir.
I would move that we go into executive session to discuss some personal matters.
Madam
confidential
Chairman,
matters.
second motion.
We have a motion and a second for executive session. Could you do the roll call, please?
Ms. Renato,
Yes.
Mr. Roche,
Yes.
Mr. Wise,
Yes.
Ms. Jackson, Mr. Marabella,
Yes.
All right, thank you. We have a unanimous vote to convene an executive session to discuss confidential matters. Stand by, we'll be back shortly. All right, let me see, is everybody back? Yes, everybody's back in. We are back in regular session and we'll be voting. Mr. Wise will be first.
Okay, at this time, Mr. Johnson, I'm gonna be voting. My vote is today would be to grant your commutation. Hold on just a second. Okay, commute your sentence to 99 years with parole eligible after serving 25 years. Okay, thank you.
Yes, sir.
All right, Mr. Marabella?
Thank you, Madam Chairman. Mr. Wall, it's good to see you. Haven't seen you in a while. Great to see you. Shocked that Tony Clayton allowed you to talk and not him come today.
I said it's rare, Judge.
Certainly appreciate your comments. And one other thing I want to put on the record, that the packet actually reflected that I was the sentencing judge. I was not the sentencing judge. Judge Daniel was the judge and the sentencing judge. I simply sat ad hoc after he retired in his place, and I assume that's why they sent me the letter. So I had no connection whatsoever with this case. In listening to all that Mr. Johnson has accomplished, especially his hospice work and all of the other things he had, it would be my vote as well to commute his sentence to 99 years and make him parole eligible after he serves 25 years. So that would be my vote today as well.
Ms. Jackson?
Mr. Johnson, I will concur as well with the recommendation of my colleagues, but I will also point out that when interviewed in 2019 for the parole for the clemency hearing, the victim's sister indicated that she was not opposed, that she felt at that time that you had served enough time. She recognized the pain caused your family and her family, and she decided that she would not oppose your request for clemency. So my vote is to grant a commutation to 99 years with parole eligibility after having served 25 years.
Thank you, Ms. Jackson. Mr. Roche?
Thank you, Madam Chairman. Mr. Johnson, you should be commended for your achievements while incarcerated, your service to the offender population as hospice caretaker, and many other things that you've accomplished over the last 23 years. It is significant that the sister of the victim is unopposed. It's very significant for me as the victim's advocate on this panel. Along with a low risk assessment, positive remarks by warden, great disciplinary record, and the family and community support that I saw in the letters that were submitted, my vote would be to commute this sentence to 99 years with immediate parole with parole eligibility after serving 25 years.
All right, Mr. Johnson, I do agree with my colleagues based on the hard work that you've put forth, the positive comments by the staff there, and particularly your work with hospice and service to others. My vote is the same. I see your mom is excited about it, so we'll make that recommendation on your behalf that your sentence be commuted to 99 years and that you be parole eligible after having served 25. Good luck to you, sir. Thanks
Thank you,
everyone for your
ma'am. Thank you for-
participation today.
So that was interesting that they brought up him maintaining his innocence even until now, but that wasn't the point of this hearing. We have seen people show up to their hearings and still maintain their innocence, even though they knowing it would hurt them. We have a playlist for that. I'll link it. What's interesting about this is that he did go out and say he did it and say all the words that he had to say to get the hearing. And I will share some information with you after that does touch on some of the evidence or lack thereof. You kind of wonder, though, when the Innocence Project isn't involved. But maybe they were. We don't know about it. But here's the original article written in 1998, updated in 2005. A college student was arrested and accused of this shooting Tuesday that killed one man and wounded 3 children at a holiday parade honoring Dr. Martin Luther King. Brandon Johnson, who's 19 and a student at Southern University in Baton Rouge, was booked on murder and attempted murder charges Tuesday for shooting that the scattered crowd of 500 marchers and spectators during the King Day ceremonies on Monday. A grand jury is expected to hear the case against Johnson in about 3 weeks. And they were seeking I think they were seeking the death penalty. Police said that the shooting resulted from a simmering dispute involving Johnson, the man killed in the shooting, a 20-year-old James Carter, and others. The subject of the dispute remained unclear. Carter was intended victim, police chief said. Carter was among the spectators watching a 17-year-old brother, a member of the band that led the march. Other shots hit a 7-year-old girl, an 11-year-old girl, and a 9-year-old boy. All were in stable condition. Pierce said Johnson fired after a fistfight erupted along the parade route. It was unclear whether Carter was involved in the fistfight. It's such a possible thing to understand. Now, here's what Richard found, who knows, deep inside the internet somewhere. It's basically the comments of someone who, and I can't speak for the authenticity of anything that is written here, right? But the question that he faces is, was he actually guilty? And so he has like commentary that he puts in here, and then he has his own commentary. And I'm only going to read the facts and not review his commentary. But I'll put the link in if you want to read the whole thing. So it says, well, to be honest with you, I had not followed up on the trial and the events leading to it a few weeks before the killing. I was kind of preoccupied with her survival, her hospital stay in town, and bewildered children, both the victim and the accused. Like many of you, when I saw the accused being taken away, I felt he was guilty. I don't know who it is that's writing this either. I hadn't thought much about it until I had a conversation with one of the jury members. So he talks about what he heard from one of the jury members. I want to keep this anonymous, so I'll just call him Mr. Doe. What Mr. Dose said frightened me, and it should scare you into opening your eyes into the fallacy of the American justice system, a system that could easily accuse you of murder in the first degree. Well, I think all of our eyes have been opened to the problems with the system. Here are some quotes from one of the 12 men and women that sentenced, in my opinion, an innocent 20-year-old man to Angola Penitentiary for the rest of his life. I didn't like the way he dressed for the trial. He was too dressed up. He was wearing a suit and he looked so neat. I felt like it was a big put on. He was such a put on. Then, he goes to comment. I'm not going to read the commentary. I'm just going to go for what the juror said. I didn't like the way he looked into the face of the jury. He acted too much like he had been coached by the attorney, Ozzie Brown. He had 6 eyewitnesses who said he did not do the shooting, but I didn't believe them because they were sitting in the van that was too far away. These witnesses were friends and family members. So there were 6 eyewitnesses, I guess, that took the stand that said he didn't do it. I believe the eyewitness that were nearest to the scene. Now, this guy does comment and say that those people were also gang members or something. They never did find the gun, but it didn't bother us. Well, the forensic test for the gunpowder on Brandon Johnson's hands were negative, but I felt that he must have washed his hands. Well, the shirt Brandon was wearing didn't have any bloodstains on it, but it didn't arrive for a long time, and when it got there, it was clean and it smelled like perfume. It was real strong with perfume. There was one juror that didn't believe that Brandon did the shooting. He was an engineer. Snare. I guess they didn't like that. He kept voting not guilty, remember, because it was so many days that the jury was deliberating. He kept voting not guilty, and we kept arguing over it for 18 hours. He wanted to see everything over and over. He had to see drawings, maps, and all that kind of stuff. Finally, he changed his mind because a drawing of the way the bullet entered the body. Okay. I don't feel like the prosecutor presented enough evidence for a capital murder in first degree, so he did not get the death penalty. I just felt that he was guilty. It was just a gut feeling. Now, again, I don't know who, but if a juror said it's a gut feeling, that is pretty scary. But this is all the other information. I don't know why he didn't appeal, but I don't seem to, Richard couldn't find it if he did. And what happened is that he actually has, so this hearing took place in 2021, and the governor did commute his sentence, and he has a rehearing on December 14, 2023, which we will now go and play. But I think it's highly unlikely that he'll get denied unless he had any write-ups in this time period, right? Actually, Richard did find the court transcript, so he did have an appeal. So let's watch the hearing. Oh no, I don't know if I was sharing my screen this entire time with what I was going over. That's actually annoying. I'm sorry if I wasn't. This is what I was looking at in case you didn't see it. But we do have the court hearing, the appeal. So first let's watch this parole hearing and then we'll go over the appeal.
Governor, that your sentence be commuted to 99 years and that you be parole eligible after having served 25 years. And Governor Edwards signed that recommendation on September 26th of this year. So making you parole eligible. So that's why we're here today. Is that right?
Yes, ma'am.
Okay. Your case has been assigned to me, so I'll take the lead on the interview. So you've been in jail 26 years?
25 years, 10 months, and 25 days.
Close to 26 years. Okay. So at the time of your hearing, the reasons mentioned to the governor for the favorable recommendation was that you, based on your conduct, based on the positive remarks from the staff there at Angola, you had no other past criminal record other than this arrest. At least one member of the victim's family was unopposed. You had a low risk score. You do community service work within your prison community. You have completed good programs, and you had good family and community support. So since your hearing in 2021, what has changed in your status? Anything?
No, ma'am, I have continued to be a servant to the people. I'm continuing to be a corrections court reentry social mentor, helping young men change their lives. I am still a hospice volunteer, doing end of life nursing care, still with the Louisiana Braille program, giving young blind school kids an opportunity to have the same opportunity as well as young school kids that can see, and just being a servant, still helping the elderly as well.
How do you help the elderly? You work in hospice, don't you?
Yes, ma'am. And healthcare.
Is that your job?
No, ma'am. My job is a reentry social mentor. That's volunteer work that I do.
Okay. It was mentioned to you during your pardon hearing, and I'm sure you recall that there was pretty significant opposition to your any favorable consideration for you. That opposition is still there. You need to know that.
Yes, ma'am.
If you could, the law prohibits you from speaking to any of the victims. You had more than one victim, you had multiple victims. But if you could say anything to the victims, what would it be?
I'm definitely remorseful for the pain and the awful hurt that was caused to the family, because they didn't deserve that. And no one deserves to go through any type of trauma or pain whatsoever at any time. And I'm very, very remorseful for that.
Of course, the district attorney remains opposed. The sheriff's office in Baton Rouge, East Baton Rouge, says it's insufficient time. And we also have another ADA who says it's insufficient time. So why do you think we ought to vote favorably for you again today?
I'm asking the board for mercy and a second chance. I'm much older now and much mature now, and I just see life differently. And I understand my purpose now. My purpose is to serve others and help others and just be a bright spot to a dark community, just helping people.
So tell us specifically how you plan, if you are successful and you did get out on parole, how would you do that?
Well, ma'am, just continuing community service. I'm real big on community service. I'm real big on just being a servant and helping others in any capacity, in any arena that I can. If I'm released by this board, I plan on just helping at-risk youth, because that's something that I just feel like with this generation right here, they need help, and they need to see people like me to tell them right from wrong and just show them. And also our elderly community, whereas hospice centers, nursing centers, just go volunteer and just help.
All right. This is your only arrest, is that right?
Yes, ma'am.
All right. Let me, Warden Falgout, is there anything that you want to add to the discussion?
nothing has changed in his status as far as him continuing to be a Class A, working as a reentry mentor and volunteering his time. So he continues to keep on that same track.
Thank you. Mr. Roche?
I've read your record. It's an excellent record of service to others. And I need to know exactly how you're going to support yourself when you're released.
Yes, sir. If I'm released, I plan on going to the Louisiana Parole Project. And once completed, I have a job from Brightside Day Habilitation Center and also a job at European Car Care, sir. I plan on working 2 jobs.
Are you a mechanic?
No, sir.
What are you going to be doing for Mr. Troy?
Anything that's needed. Anything, whatever he needs, I told him I'll be available and whatever type of service.
Ms. Hogan,
Yes, sir.
this is an acquisitive board member. There were 3 other victims in this offense, 3 juveniles. Do you happen to know the status of those juveniles today?
No, sir, I don't.
Okay, thank you.
Thank you, Mr. Roche. All right, we'll lost my sheet, stand by. Can you give me another one? I've already lost my lips. Hang up, stand by. We're gonna hear from the folks who, I tell you what, your parents, let's hear from Mr. Johnson first.
Just stay where you are and have a.
Yeah, thank you.
No, you can stay right there and talk.
Hi, how y'all doing today?
Good.
I'm John Jackson, Brandon's father, and I'm kind of nervous, but
Okay.
I would say I really would like to have my son home. I think he'll be a good asset to the community because he really takes his community service and his work very serious, and he has a lot of support from the family. So we'll make sure that he have whatever he needs to be very successful.
Yes, sir, thank you. Mrs. Johnson?
Hello, how are you all doing? First and foremost, I want to say thank you all. I want to commend Brandon for a wonderful job that he has done as maturing as a man now, up here for 26 years. I'm his mother, and it's been a hard road for us all and the victims' families. And I want everyone to know that our family are very grateful for every opportunity that has been allowed for Brandon here today and further. And as his father stated, his family, we all would like to thank you all, the ones before us and after that won't get a chance to speak. We want to say thank you all. And Brandon will be employed. He has done hospice very well up here and mentors to a lot of people up here. And I'm very proud of him now, the man that he have became. I own a healthcare facility that he would be employed at, continuing to help individuals with adult individuals with disabilities.
Yes, ma'am. Well, thank you very much. Mr. Myers?
Good morning, Kerry Myers with Louisiana Parole Project. I think this board has seen that Brandon's length of incarceration has been about service. As a healthcare orderly, as a hospice volunteer, as a social mentor, as a reentry mentor, it's been about service. That's because that's who he is. We are here to support Brandon through his transition. Brandon will be actually in the Baton Rouge area. when he finishes our program, we will provide case management with Brandon and support throughout the entire first year of his release. But as you heard me say before, once a client, always a client. That's how Parole Project looks at our clients. So we will always be here for Brandon to make sure that he has the resources that he needs, with the strong family support that he has, with Parole Project behind him, with the mentorship that we'll be able to provide. Brandon is going to be successful. There's no question. So we just ask this board to look at these factors and grant us parole today.
Thank you, Mr. Myers. Okay, we'll hear from Mr. Carter's family now. I'll let you guys figure out who you would like to speak first. You would just step up to the podium and introduce yourself and tell us your relationship to Mr. James.
Now, it's my opportunity. I'm James Carter, sister. And I got 4 more colleagues, 2 of which don't live here. They stay in Maryland. And I just want to say, I can read my love. It's me. For the honorable members of the Parole Board, on behalf of myself and my brothers, we would like to say that letting Mr. Johnson out of jail would be a big mistake. Today was the first day that he has apologized in over 20-something years. I had wrote it a big mistake because he not once apologized for his wrongdoing to any of the victims, not only my brother. And we feel that he did the crime and he should serve the time. My brother James Carter can not be brought back to us. So why should he get out? A good time or be given an out date? As I think back to the trial date when Mr. Johnson testified, he was asked, how did he feel when Ms. Anderson walked in his courtroom on a walk, partially paralyzed? And he said he didn't feel anything. So again, I asked, why should he get out? Our mother, whom is now deceased, wants us to continue to fight for our brother James Carter. So this is why we want him to stay in jail. And also, if he gets out, we are scared that someone or anyone, or including him, may harm our family. So I think he needs to stay in jail. Thank y'all from the bottom of my heart. Thank you.
Thank you, Ms. Henry. Carter?
Thank y'all for the opportunity to come before the Lord. My name is Faye Henry. I'm the aunt of James Bartholomew Carter. He was named after his great grandfather, which was Reverend James Bartholomew Carter. James Bartholomew Johnson, excuse me. My mother is 84 years old, so she wasn't able to feed because she hadn't gotten out of the hospital. So I told her I'll represent. I appreciate the opportunity to be heard by the Louisiana Board of Pardon and Parole. Brandon has not served enough time for his crime. I think that the appropriate time for Brandon Johnson to serve for his crime has been decided by multiple people. It has been decided by the legislature, who determined that life without the benefit of probation and parole or suspension of sentence was the correct sentence for his life. It was determined by the jury and the judge, who convicted him of the murder, which carries the length of incarceration without benefits of probation and parole. James B. Carter was killed at the age of 20. He was killed January the 19th, 1998, 6 days after his birthday, which was January the 13th. He went to the parade to watch his younger brother play in the band at McKinley High School. Instead of celebrating and enjoying a beautiful Martin Luther King parade, his life was taken by the hands of Brandon Johnson. This was supposed to be a day of peace, celebrating a great man, where the community comes together as one. Words cannot begin to describe the level of excruciating pain that we experienced due to the horrific death. My nephew died at the age of 20. His mother died at the age of 48, heartbroken. She was never the same after her son's death. Mary Carter told me she didn't want the death penalty, but she wanted him to serve the rest of his life in prison so he could think of what he had done, as well as the kids that suffered gun wound shots for the rest of his life. Brandon Johnson attended the parade with a gun, while other people were there to enjoy the celebration of Dr. Martin Luther King. Brandon Johnson was armed with a weapon and killed James Bartholomew Carter and shot several kids under the age of 12 years old. He showed no remorse, and as of today, he just now shows a little remorse, I guess. I can't forgive, but I can't forget that he took away my beautiful, handsome nephew. The pain has been with me and my family. Please keep him in, and maybe after he has served 40 to 50 years, he may be released without harm to society. If you do decide to release him, please have where he cannot live in Baton Rouge, Louisiana, or if he sees any of my family members, to stay away or go in a different direction. Thank you.
Yes, ma'am. Thank you. All right. Brandon, is there anything you want to say to us before we turn it over to Ms. Hogan?
Yes, ma'am. I would like to thank the board for giving me this opportunity to speak. I am very deeply remorseful for the death of Mr. Carter and the pain that was caused to his family and his friends. I am not the same 19-year-old kid who entered this prison. There's not a day that goes by that I don't ask God to continue to make me a man of purpose and lead by example. I'm a mature man. I'm compassionate. And I just want to thank this board for this opportunity. Thank you all. God bless you.
Thank you, Mr. Natsa. When I was introducing everyone earlier, I missed Nurse Tonya Faust, who's also in the room. That's Brandon's supervisor from the hospice program. Brandon came to prison when he was 19 years old, and he is the first to tell you how grateful he is for the past 26 years. He's found his calling within this prison. A lot of people might go in one direction, but Brandon went in another. There are people in this room today who met Brandon when he first got off the bus and have been friends with him ever since. And the person that Brandon is today is truly the person who he's always been to a certain degree. He's found his calling, and he is given back at every opportunity. Before, he was a reentry social mentor. He was working as a tutor. There are, within the materials we submitted to the board, letters from mentees who talk about the profound impact that Brandon has had on their lives. People that have gone home write to him still and say that I wouldn't have made it had you not showed me the way. He's always thinking of other people. Just as a personal example, he found out once that I was sick, and he had he got his family to ship me vitamin C and orange juice and other things because he heard that I was very sick. And that's just who he is. He's not pretending. He's not becoming anybody other than who he truly is. And he is going to make any community that he is a part of a much better place. In addition to everything that he has mentioned that he's done since being granted clemency, he's also completed additional programs, trauma healing, Tyro. He's continued to attend church regularly. He has tremendous family support, and he hasn't used a moment of his incarceration as idle time. He's sat by the beds of dying people here for the past 11 years and mentored to people in times of darkness. So we would ask this board to consider all of this and to grant Brandon release with any conditions that are deemed appropriate. Thank you.
All right, thank you. All right, Mr. Johnson, I think we are prepared to vote. I'll be voting first. I've listened very intently, today and at your other hearing back in a couple of years ago, and I'm impressed with the work you've done. It's obvious that you do want to give back, and I guess that's your way of kind of making up for the harm that you've caused multiple families. I've listened to members of the Carter family and really appreciate them being here today. And this is tough, but I think, I stand by the vote that I cast on your pardon application. My vote today is to vote to grant your parole to the parole project plan. I would add special conditions. If you are successful today, add special conditions that you have a curfew 10 p.m. to 6 a.m., that you do at least 8 hours a month of community service work, helping at-risk youth, and that you have absolutely no contact with any member of the Carter family or the juvenile victims' families. Mr. Roche.
Mr. Johnson, my vote is the same with the exact same conditions. Please have no contact with the Carter family.
Mrs. Jackson.
Again, I'd like to thank everyone who participated today. Brandon, you have used your time wisely, not only to help yourself become better, but to help others also. That speaks volumes of who you are today, not who you were when you committed this terrible crime, but who you are today. And that's what we have to assess, who you are today. And so my vote today would be to grant your release of the Louisiana Parole Project with the same conditions.
Good luck to you.
Thank you all.
Okay, so I think we all felt that it was a shoo-in hearing, but now we can go over the facts of this case, and I glanced over it, and it looks pretty sketchy to me. I mean, but I haven't gone over it in detail, so we'll do it together, and it might take a while because it's a long appeal. So buckle up. So here are the facts of the case, and thank you, Richard, for finding this. It was, as we know, a parade that was held in Baton Rouge, Louisiana, Martin Luther King Day, January 19, 1998, in which the combined marching bands of 4 local high schools participated. The band members gathered at Baton Rouge High School to attend a program in honor of Dr. Martin Luther King Jr. before lining up for the parade. The parade proceeded on West Government Street in the 2 right lanes of the 4-lane road. The band was organized by instrument sections, with the drums followed by the clarinets, marching as the last two sections of the band. Marching last in the parade behind the band were the Capitol High School Pepsters. Brandon Johnson, the defendant, August Valerie, Dwayne Dunn, and Jermaine Johnson arrived together and attended the program at Baton Rouge High School. During the parade, these individuals, along with others, walked alongside or behind the band to keep parade watchers from walking between the rows or otherwise interfering with the band. Defendant and August Valerie both wore orange shirts that day. Defendant's shirt was a plain orange Tommy Hilfiger shirt, and the shirt worn by August Valerie was an orange FUBU shirt with white lettering. During the parade, a fist fight occurred on the north side of Government Street near the intersection with 16th Street. The last few rows of the clarinet section were passing this location at the time. At some point during the fight, a gun was fired. J.B. Carter was fatally struck with 5 bullets. 3 other individuals also sustained gunshot wounds. There was a lot of confusion in the crowded area during the fight, and after the gun was fired, the band quickly dispersed with many of the parade participants and onlookers, including the defendant, August Valerie, and the other 2 individuals with whom they attended the parade, running and walking west on Government Street to an area near the railroad tracks. Subsequently, these individuals were driven back to Baton Rouge High School in a van owned by Linda Drury. After arriving at the high school, they got into the car which they had traveled to the earlier that day and were then dropped off at their respective homes. The defendant got out of the car at his father's house and at some point changed clothes. Later that afternoon, the defendant went to his grandmother's house where several other family members had gathered, and it was subsequently decided to have the defendant go to the police station to give a statement. Although the defendant and his family waited many hours at the police station, the defendant never gave his statement. Eventually, an attorney who had been called by the defendant's family arrived, and shortly after midnight, the defendant was arrested. Okay, so did we all catch that? He was at the parade. There was the fist fight, the shooting. He got a ride back, went to his grandmother's house. Defendant went to his grandmother, where the several other family members had gathered, and subsequently decided that the defendant should go to the police station to give a statement. Okay, so he definitely was involved, right? He went to the police station to give a statement. He waited for many hours. The defendant never gave a statement. Eventually, an attorney who had been called by the defendant's family arrived shortly after midnight. So, they did the right thing. They went there and he lawyered up. Now, sufficiency of the evidence, and that is still the act of kind of an innocent person, I would think. It's like, hey, I was in the wrong crowd, but I mean, you can argue both ways, but still, it's okay. So, in the sole assignment of error, the defendant contends that the trial court erred in convicting him because there was insufficient evidence to establish beyond reasonable doubt the essential element of identification of the perpetrator. The standard of review for sufficiency of evidence to uphold a conviction is whether or not, viewing the evidence in the light of most favorable to the prosecution, a rational trier of fact could conclude that the state proved every element of the crime and the defendant's identity as a perpetrator of that crime beyond a reasonable doubt. In the highly charged atmosphere of the parade, the fight, the shooting, and its aftermath, it is understandable that conflicting testimony was elicited from many witnesses who testified at trial, where there is conflicting testimony as to the factual matters. Credibility of witnesses is within the sound discretion of the trier of fact. I'm not familiar with that word, trier. An appellate court does not Sorry, I just moved. I'm trying to get the. Gosh, sorry about that. Did I just lose my place? Here we go. An appellate court does not rewrite credibility of witness when reviewing sufficiency of evidence. The tier of fact is charged to make credibility determination and may, within the balance of rationality, accept or reject the testimony of any witness. Thus, reviewing court may impinge on the facts finder's discretion only the extent necessary to guarantee fundamental due process. Preliminary. It should be noted that the incident occurred in the midst of a crowd. It was estimated by one witness that 80 to 100 people were in the area immediately surrounding the fight. The state presented eyewitness testimony of 8 individuals and other witness testimony in support of its case against the defendant and the perpetrator of the crime. The defense presented 5 eyewitnesses and several other witnesses who testified that August Valerie was the one who fired the gun. During the trial, witnesses there were questions concerning the dates at which they came forward with other observations. Although many of the state witnesses spoke with the police soon after the incident, many of the defense witnesses did not contact defense counsel or defendant's family until shortly prior to or during the trial. Okay. All right. All of the witnesses described August Valerie as a large black man wearing an orange FUBU shirt with white lettering. He carried a camera case by its shoulder straps during the parade. Several witnesses also noted that August Valerie carried a hairbrush in his left hand. Okay. The defendant was described as being a thinner black man than August Valerie with waves in his hair and wearing a plain orange Tommy Hilfiger knit shirt. These descriptions all are corroborated by the photographs introduced into evidence. So, in a nutshell, to sum that up, the state had, 8 witnesses, and all those witnesses spoke to the police immediately after. The defense had 5 witnesses. None of them spoke to the police. They only showed up basically right before trial. So that scenario, I believe, is definitely in favor of the state when you have police that interview 8 witnesses with the same story immediately after the fight. From the state's witnesses, information was presented that an argument between J.B. Carter and August Valerie had been ongoing for some time prior to the actual fist fight. Testimony of defense witnesses corroborated this fact. While walking along the right side of the band and continuing their argument, August Valerie and J.B. Carter came between 2 of the witnesses who were watching the parade from the north side of the government street in front of the beige brick building located between 16th Street and Turkey building. At this point, witness testimony placed defense somewhere behind these 2 individuals. J.B. Carter threw the first punch in the fight. During the fight, August Valerie faced toward the beige brick building, while J.B. Carter faced away from the building. At some point, Charlie Miles, a friend of J.B. Carter and defendant, may have joined in the fight. Although testimony was introduced which identified defendant as participant in the fight, conflicting testimony by defendant's mother and John Pierce Meyer was also elicited. The fight and subsequent shooting incident happened in front of Takesha Jones and Maurice Franklin. The other state witnesses who saw the fight were either participants in the fight or in close proximity to one of the participants. Of those defense witnesses who saw the fight, Clarence, Christopher, and John, Meyer testified that they never saw the defendant during the fight. Chris could not definitely say one way or the other, and 2 other defense witnesses, Cleve and Daniel, testified to seeing the defendant get hit during the fight and stumble backwards. Chris testified that although he did not see August Valerie get knocked to the ground, he did see him on the ground. None of the other witnesses testified to having seen August Valerie get up off the ground. Several witnesses testified as to seeing the defendant get knocked down. So again, the defense witnesses don't seem sketchy at all. I mean, they still, just because they came at the defense, it's not like, and in my opinion, and I don't know. It's just a lot of conflicting evidence. The shooting. According to the state eyewitness testimony, the defendant was hit during the fight, which caused him to stumble backwards into the crowd. Tamika, Rashika, Takesha, Maurice, Charlie, and Jermaine all testified that the defendant, upon rising, had a gun in his hand and started shooting. All of these witnesses were standing within close proximity to the fight. August, who testified he did not see the person firing the gun, testified the bullet came from behind him. Eyewitness testimony placed the defendant as being behind August immediately prior to the shooting. Sonia, a clarinetist who marched in the row immediately ahead of the fight, testified that she could plainly see August during the fight and shooting incident, and he never had a gun in his hand. So, defense witness Clarence, Chris, Cleve, Daniel, John, and Pierre all testified that August Valerie was the person who shot the gun. I mean, how are you gonna? There's just so many witnesses. Defense saying no, prosecutor saying yes. How would a jury actually? Two of these witnesses, Clarence and Chris, were watching the parade from the south side, Government Street, near its intersection with 16th Street. Although Clarence testified that only 3 to 4 people were between him and the fight. Chris, who viewed the incident from a similar vantage point, estimated 20 to 30 people were between him and the fight. This witness also testified as to observing August on and off for approximately 30 minutes prior to the fight. In contrast, these two defense witnesses, the other defense eyewitnesses, were nearer to the fight. Cleve testified he was 3 to 5 feet from the fight. Daniel was marching in the last row of clarinets on the left-hand side. And John, I don't know if any of you are following this, but it's a lot of people to have been within an arm's length from the fight. These 3 witnesses testified they saw August pull a gun from under his shirt and fire it. So, I mean, these 3 people say it was August. And J.B. Carter continued to fight after he heard the first gunshots and admitted that he did not see a gun in August's hand. The defendant testified on his own behalf and denied he killed it. So he testified on his own behalf. The gun used in the incident was never recovered, although testimony was consistent that it was a .38 or a .357. I mean, okay, I get that. So 38s tend to be revolvers and .357 tend to be revolvers, but the difference is so massive. I mean, a .357 is a hand cannon and a .38 is not. So even just that discrepancy, the size, I mean, I know that you can get smaller .357s, but the sound, you would think, I don't know, how is that? But anyways, I'm not a gun expert, but I am an enthusiast. So if any of you are experts that think I'm wrong or concur, please put it in the comment section. Which description was corroborated by forensic evidence? Conflicting descriptions of color of the gun was elicited from the various witnesses who testified at trial. Both Takesha Jones and Maurice Franklin, witness who testified to seeing defendant shoot the gun, described the gun as small black steel revolver. That just doesn't sound like a .357 to me. Witness who identified August Valerie as the person who shot the gun, described as being either chrome or shiny or dull silver color. The state witness description fits the description of the gun, which Joseph, August, Dwayne, Jermaine, blah, 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 were carry on numerous occasions. August testified that the defendant frequently carried a gun when he went out, although he was unable to describe the length of the gun's barrel or identify its caliber. Defense testimony conflicted with these statements. A longtime friend of the defendant testified that he had never seen the defendant with a gun, although he did admit that his friendship with the defendant had lessened somewhat in the past year. Elizabeth, the defendant's mother, also testified that she had never seen the defendant with a gun. J.B. Carter was hit by several bullets and fell to the ground, and 3 other individuals sustained gunshot wounds during the shooting. 2 of the 5 gunshot wounds sustained by J.B. Carter were fatal, according to Dr. Alfredo, the doctor who performed the autopsy. The trajectory of the bullet entering his left leg was from the back to the front, which indicated to the doctor that Carter, there goes my dryer, had been shot by a weapon located behind and to the left of him. The fatal gunshot wound behind his left ear was from the back to the front of the upward, which the doctor stated was more consistent with the gun being fired from someone knocked to the ground and coming up firing. So there they have, remember when we spoke about the engineer who made his decision after seeing the ballistic map out? So that could have been the testimony that swayed that final juror. Event after incident. Tamika, JB's cousin, who had been walking with JB Carter prior to the fight, testified that although she and Rashika Dawson ran behind the building during the shooting, she ran to JB Carter immediately after he fell to the ground. From this position, she saw the defendant momentarily lean over JB and hit the bottom of the gun before he ran west on Government Street. According to this witness trial testimony, this permitted her an opportunity to look closely at the defendant to see the waves in his hair and to be positive in her identification of him as the perpetrator of the crime. The testimony of Rashika Dotson and Charlie Miles confirmed Tamika Welsh's testimony regarding her return to JB Carter's side. Takesha Jones testified although she saw the defendant run back into the crowd immediately after the shooting and denied seeing the defendant standing over JB Carter or anyone else, JB until after the shooting had stopped. You know, you could see how juries can get it. You got to keep track of everyone, what they're saying, and then what it comes down to. How do you believe one juror over the other juror? It goes on, talking about each witness, what they saw, didn't see. The videotape. So there's a videotape admitted into evidence depicts the hundreds of people running down Government Street. It shows defendant running while looking over his shoulder and shows him to be ahead of August Valerie. August testified he was behind the defendant because the defendant is a faster runner and because he had to stop and walk some of the distance. While viewing the video, questioning was conducted concerning what was described as a bulge in the defendant's front pocket, with the suggestion being made that it could be a gun. I just wonder how clear this video is. Remember the year that this was taken. I mean, come on. August Valerie testified that it did not look as if anything was in the defendant's pocket, and the defendant testified he did not remember what was in his pocket at the time, but that he usually carried money, a lip chop, and keys in his pocket. Linda Drury, who is related by marriage to August Valerie's family, testified that she backed her van into the field of the north side of the Government Street near the intersection of Betty Robinson in order to watch the parade with her son and two grandsons. She testified she heard the gunshots and then saw all of the people running towards her on Government Street. I don't know. Are you guys bored yet? We've been doing this a little while, 20 minutes. I'm looking for something a little bit more definitive. Upon arriving at Baton Rouge High School, the defendant, August Valerie, Jermaine Johnson, Dwayne Dunn, got out of the van and into the car in which they had driven to the school earlier that day. The defendant and Jermaine sat in the back seat while August Valerie and Dwayne Dunn were in the front seat of the car. Jermaine, who testified he did not hear the defendant say anything in the van, testified that in the car, the defendant said he hoped lives were spared and that he didn't mean to shoot, but that it was something he had to do. Dwayne, who testified he heard the defendant make such a statement in the van, testified he also heard the defendant make a similar statement in the car. August testified he could not remember what comments were made in the car. Defendant denied making any such comments and described the conversation in the car to be one of disbelief, such that everyone was wondering out loud as to how such a thing could have happened on Martin Luther King Jr. Day. There's another sound. So you have one person, one witness who claims that he said those things, one who doesn't remember, and it definitely, you could have said anything. Defendant returned to his father's house sometime between noon and 3. He changed his clothes and at about 4:30 p.m. spoke to his mother on the telephone and was thereafter picked up by his grandfather and taken to his grandmother's house. Defense witness testified that thereafter the defendant went to the police station with his mother, father, and grandfather in order to give a statement to clear his name. The defendant testified that although Detective Smith spoke to his parents soon after they arrived at the police station, no one spoke directly to him for quite some time. An attorney who was contacted by the defendant's father later that night arrived at the police station by 11 or 11:30 p.m. The attorney advised the defendant not to give a statement after having learned the police intended to arrest him. Again, we went through that and it seems they did everything right. Now the police investigation. So we're getting near the end here, so you can see. Almost done. Police arrived at the scene of the shooting within minutes after it occurred and began their investigation. Detective Smith spoke to various witnesses, including Maurice, Tamika that afternoon, and reviewed the Channel 2 videotape. From viewing the videotape, the police noted, remember videotapes? A bulge in the defendant's front pocket and a wave pattern in the defendant's hair. A photo lineup was created and taken where Tamika was staying. She identified the defendant from the photo lineup, but in doing so commented that he looked darker in person. The search warrant for the gun and orange shirt was executed at the defendant's father's house. However, even though the defendant's father directed them to the room in which his son was staying, neither item was located. The police subsequently spoke with August Dwayne Germain, whose statements, according to the detective, enhanced the case against the defendant. A trial detective Smith testified that as a result of the investigation, he had no doubt in his mind that the defendant was the person who pulled the trigger and that August was not. And I would say that this statement could be used against the prosecution. No doubt in your mind, really, after just listening to that testimony? At trial, this witness explained that people frequently look brighter in photographs than in person. Okay, I don't know if we need to go through that. It was noted that the defense that no physical evidence tied the defendant to the shooting. There's no physical evidence, in as much as the gun was not recovered. I don't know really in as much as one word. Recovered, and that a gunshot residue test was not conducted. They messed up. How do you not conduct a gunshot residue test? Like, for real? Pat Lane, a crime scene investigator, testified that the result of such tests are limited by time, and that after the passage of 6 hours, the test is never utilized. Is that true? I have a hard time believing that, man. In addition, Elizabeth John testified that she felt Detective Smith would treat the defendant unfairly, given the detective's prior relationship with the Valerie family. Detective Smith denied any further treatment of defendant and stated he gave the defendant every break he could. I mean, I guess what it could be is that if you're nervous that the person could have washed their hands, you don't want it to do the residue test because a negative test is worse than no test as far as the detectives are concerned. But if you're looking for justice, wouldn't you do the test anyways? He admitted that he had gone to school with August Valerie's aunt, but he was not close to them. He testified that he also knew the defendant's family, having gone to school with some defendant's uncles and aunts. After a thorough review of the record and our application of the appropriate standard of review, which requires us to view the evidence in the light of most favorable to the prosecution, we are convinced any rational trier, is a trier another word for juror, of fact could have concluded beyond a reasonable doubt that Brandon was the perpetrator of the crime for which he was convicted. The instant guilty verdict indicates that the jury accepted the testimony of the state's witnesses, which evidence was sufficient to negate any reasonable probability of misidentification. As the trier of fact, the jury is free to accept or reject in whole the part of testimony of any witness. The jury's decision to accept testimony of the state witness was rational and therefore cannot be overturned by the court. Conviction and sentence affirmed. So we went through all of it. And frankly, I don't think there is enough evidence to prove beyond a reasonable doubt that he did it. You have, what was it? Is it, you have maybe 5 defense witnesses and 8 it's whatever. There's enough witnesses on both sides that seem to be impartial and to have seen different things. And it's a known thing that people also do missee things when there's chaotic events with a lot of with crowds. I mean, I don't think it's beyond a reasonable doubt. I think that you could easily have had a mistrial, a hung jury. There's no evidence at all. It's prosecution witnesses against defense witnesses. I don't know how that is ever beyond a reasonable doubt by the definition. Whether you want to say guilty if you believe he was actually guilty, I don't know. Now, again, remember, he said he was guilty at his hearing. But he did that as a strategy because he was afraid that if he didn't, he wouldn't get commuted and paroled. Although he might have. We have seen people come up and say, I am innocent, and get the parole and commutation. It's rare, but we have it. I have the playlist. I'll put the link here if you want to check out. There are very few hearings, but we have them. And I have frankly, where my perspective, I have no idea. I can't do a Dr. Grande where I believe that he was innocent by the terms of, reasonable doubt, but guilty in reality. And I have no idea. I don't think anyone would really know except the person who did it. But he is now paroled, and after spending, a long time in prison, he's going to, I hope he does well. I hope we don't see him again. I'll put it that way. With that, I'll let you go.